This seemingly straightforward action brought by a linen rental and laundry service against a nursing home to recover over $135,000, allegedly due and unpaid for services rendered, is complicated by the fact that the home has recently turned its operation and its assets over to a temporary receiver, pursuant to a contract entered into by the home, the receiver. In answer to and on behalf of Lakeside, which has defaulted in appearing, and for a stay of all proceedings pending the termination of the receivership, plaintiff opposes all aspects of Peregrine's motion and cross-moves for a default judgment against defendant Lakeside Nursing Home, Incorporated, for the portion of the debt that was assertedly incurred prior to the commencement of the receivership, and severance of the remainder of its claim, which arises from services rendered after the receivership began. The receivership contract contains several provisions dealing with Lakeside's pre-receivership debts. It expressly provides that Lakeside shall remain liable for such liabilities, and that nothing therein shall be construed to diminish any rights that any third party may have to proceed against Lakeside with respect to financial obligations arising out of exemptions occurring prior to the date of the contract. Affidavit of Louise M. Thurlow, Esquire, dated March 8, 2001, Exhibit D, Receiver Agreement, Sections 3.9, Exhibit D, Receiver Agreement, Section 3.9, 3.10, compare Section 2.5 with respect to Lakeside's possible failure to satisfy outstanding obligations. The agreement shall not be construed in a manner inconsistent with applicable law governing receiverships, and while the receiver is authorized to negotiate and or settle any of Lakeside's outstanding liabilities or obligations, id. at 11.1, Lakeside has also expressly reserved its right to contest or dispute any asserted liability. The agreement also addresses the potential encumbrance of Lakeside's property during the term of the receivership by requiring inter alia that Lakeside promptly take whatever action is necessary to remove any such encumbrances resulting from an execution or attachment upon such property that arises from a pre-receivership obligation unrelated to the operation of the facility. Id. at Section 3.3, no such requirement is imposed with respect to liens or encumbrances arising from debts, such as those at issue here that are related to the operation of the facility. The mere fact that some or all of a debtor's assets have been placed into receivership does not necessarily preclude the commencement of suit against the debtor directly. A mortgage may be sued to judgment, that is, a mortgagor, by other creditors, despite the fact that his or her only asset may be the mortgaged property that has been placed under the control of a receiver. The existence of the receivership affects only the extent to which the resulting judgment may be enforced against the receivership estate itself. It does not preclude a suit against the debtor to remove debts that persisted with respect to the receivership. In determining whether it is inappropriate to allow the receiver to intervene in such an action, it is necessary to consider the nature of the receivership, the interests intended to be protected thereby, and the impact that a judgment in plaintiff's favor might have upon those interests. It is apparent from the terms of Lakeside's receivership agreement itself as well as from the overall thrust of the statute sanctioning such an arrangement, see Public Health Law, Section 28101, paren 1, that the receiver's chief concerns are protecting the welfare of the facilities, patients, and in connection therewith, ensuring the facility's continued existence through a smooth transfer of operations in a new operator.
That's good. Receive